here representing 10 folks today of the 72 that were arrested and part of the legal defense team that's been put together to represent folks in these very unjust and absolutely horrendous prosecutions and arrests that occurred at Arizona State University. I was asked to report a little bit back on what happened in the court hearing today. The court hearing today was scheduled for what's called an arraignment. An arraignment is when they bring formal charges against somebody. What happened in the jail is called an initial appearance. So someone that gets arrested, they get taken to see the judge. The police officer writes the ticket, gives it to the first judge at the initial appearance court, and they read the charges, and then we argue what's called release conditions. So folks were released. All of them were told not to go back to ASU campus. All of them told not to leave the state until this court hearing today. From that court hearing until today, Maricopa County and Arizona State University had to file additional documentation to make the court official. And what happened today is that they did absolutely nothing, which part of me says that's a good thing because they were absolutely unjust arrests and people were out there exercising their First Amendment right to protest. But part of me also says if you're going to go through and arrest people and destroy their property and try to make it impossible for them to graduate from school, to get their fingerprint clearance cards taken away from them, then you should give them their day in court where they can present their evidence. Today, the case was called scratched. That means that the county attorney's office, along with ASU, did not file formal charges in these cases. And we got paperwork today saying that the charges were not filed and they were scratched. That doesn't mean the case is necessarily over. On a misdemeanor case, the county has up until a year to officially bring the charges and start the case over again. Or if they were to charge as felony, which I don't see that happening, they would have up to 7 years to file the case. So that is what happened today in court. We had arguments from the judge about whether to dismiss it with prejudice or without prejudice. And essentially, it's a little bit confusing to me as an attorney because if the case was never officially filed, what is there to dismiss, right? The charge was scratched. The case was not presented to the judge by the county attorney's office. But nonetheless, we go forward with the farce the court put together, and we argue for dismissal with prejudice. Why? Because people were affected by this. Simply being arrested can result in someone's fingerprint clearance card being taken away or suspended, someone not be allowed to go back to school, someone losing their job. All of that happened to all of my clients. We asked the judge to dismiss it with prejudice so that the case could not be brought back again. Unfortunately, not for a single case so far. I think there's probably still about another 20 to go. Has the judge dismissed with prejudice? All the dismissals have been without prejudice. Legally, that means the case can still be brought back within a year. However, hopefully, with the paperwork we have today saying the case has been scratched, individuals who have been affected can take that to fingerprint clearance, ASU, wherever it is, and show them that the case no longer exists. Yes.
If the person that was brought before this court today, if they end up getting like another misdemeanor or another charge within that year that the county attorney's office has, would that charge be added on to this incident, or this incident is completely scratched in terms of like another prosecution?
Yeah, so the question was about whether this case would affect another case if somebody has it in the future. This case, as of today, is officially closed and done for and shouldn't impact if someone gets another arrest within the next year. That shouldn't result in this case getting filed again. That decision should purely 100% be with the county attorney's office and ASU whether or not they want to file and bring the charges.
And so what is the downfall of being dismissed without prejudice?
The dismissal without prejudice, the bad part about that is that the university and the county attorney's office have the opportunity to bring the charges back again within a year if they so choose to.
Excuse me? I do know several people that they have, MCAO has brought charges as long as they're for the same activity. They brought them back to stack the charges.
Yes, thank you.